Jack Rakove is in the very top group, maybe, I don't want to say the top, you know, but it's probably true, of constitutional historians.
I want to speak this morning primarily as an originalist, and I want to explain exactly what I mean by that term. I don't mean it in the jurisprudential sense of the term. It doesn't mean that I believe as a matter of principle that the Constitution should be always interpreted in accordance with what we call the original intentions, meanings, or understandings of its text, of its framers and ratifiers. I'm an originalist as a historian, meaning I spend most of my waking hours in the 18th century on any given day, and I spend many of those hours thinking about particular constitutional puzzles. It could be the Second Amendment, it could be reapportionment, and in recent years, and not just in recent years, it could also be issues about war powers. And I'll just say, tell a very quick personal story here. When I first got interested in this subject, well before I started working on it, it was when I was a graduate student in the early 1970s, and I was a member of an organization called Reservists Against the War, which had filed a suit against then Secretary of Defense James Schlesinger in an effort to force all those members of Congress who were holding commissions under the reserve, in the reserve branches, and I was a reservist at the time, to either resign their commissions or resign their seats in Congress because the Constitution prohibits members of Congress from holding office under the executive branch. And that's when I actually first started thinking about issues of how one would talk about original intent, meaning and understanding, because I thought on historical grounds this was a great suit. That is to say that the framers would have agreed that members of Congress, as a matter of course, should not hold commissions in the armed forces. And I started thinking about the issues that have preoccupied me really the last 20 years, originally as a graduate student then. Now this is important to us, I think, for a couple obvious reasons. It's not that reading the debates of 1787 give us the only answers we could possibly imagine to the dilemmas of constitutional governance we face today, and particularly which we felt very acutely over the last 7 or 8 years or so. But it is because I do believe that any serious effort to understand what the Constitution means today should at least begin with an attempt to figure out why the clauses that we have to work with, in this case, the distribution of powers over war, national security, and foreign relations, primarily between the legislative and the executive branch. All those inquiries, it seems to me, should begin with some informed historical understanding of why the clauses in question made their way into the Constitution. There had to have been some rationale at the time. And so as a historian, and I want to present this in a disciplinary sense, as a historian, when I think about this, I need to be able to tell some story to myself, which would explain why did the framers do what they did at Philadelphia in 1787, and what would the larger American public, which was passing judgment on what they had done in Philadelphia in 1787, how would they have thought about what the framers were proposing, and how could we explain their actions in terms of their existing understandings of the concerns of the time. It's important to note this because the discussions of originalism that take place in the current academy, and particularly the legal academy, and on the federal bench, and if you read in particular Justice Scalia's opinion in the recent D.C. Guns case, the Heller case, rely upon a different version of originalism. It's called public meaning, which as I take it as a kind of dictionary exercise. It doesn't involve knowing very much about what the framers thought they were doing in Philadelphia in 87, or what they thought they were doing in New York in 1789 in terms of Bill of Rights. It imagines a kind of disinterested citizen with a lot of dictionaries and some knowledge of history, reading the Constitution and asking, what does it mean on that basis? Well, my position is we want to know what the people who adopted the Constitution, those who drafted it, those who ratified it, would have thought they were doing on the basis of what they said about it. And on the basis of the history of their own period, not just on reading a dictionary. And that's what I want to try to do this morning, in very short order. Jesse, give me the hook when you have to, because, or at least let me know when I'm getting into trouble. I really only have three basic data points I want to put before you. But let me state, I think maybe in some more general terms than Lou did, what I see as the basic issues that we've had to consider in the last 6 or 7 years, since let's say since 9/11. Being the obvious reference point, though a lot of these debates go back at least to the early 1970s and perhaps even a little bit earlier than that. So the basic argument that the Bush administration has made, and for which, by all accounts, John Yoo is a prominent proponent and spokesman, rests, and John can certainly qualify this, and I'm sure will, when his turn comes. But rest, I think, particularly on two clauses of the Constitution. The one I think that's the more interesting for us to discuss has been the Commander-in-Chief Clause. And the basic argument, which I will grossly oversimplify, and John can qualify it, but is, and I take it, one way to characterize the basic argument is when we're in war, we're in some kind of condition that resembles a war, the president is acting legitimately, perhaps with some prior congressional authorization in his capacity as Commander-in-Chief, that his authority, a robust definition of his authority as Commander-in-Chief, essentially switches off many, if not quite all, of the corresponding provisions relating to defense and security that we find in Article 1, Section 8 of the Constitution. That there's a kind of mantra, there's a kind of magic, there's a kind of talismanic quality to the Commander-in-Chief Clause that somehow trumps or switches off all these other relevant provisions that give Congress the authority to declare war, to make rules for captures of land and sea, to define piracy and offenses against the law of nations, to raise and support armies, and so on and so on. So the big reliance on just the inherent authority of the President's Commander-in-Chief has been, it seems to be, a major foundation of the administration's claims to unilateral authority. And then secondarily, there's an older argument which really goes back to the 1790s about the meaning of the vesting clause of Article 2, the clause which says, the first sentence of Article 2 says, the executive power shall be vested in the President of the United States. And the question of how you define the executive power, whether it's defined primarily in terms of some 18th century conception in which British notions derived under monarchical rule would still have some salience, or whether there's a distinctly American definition of what executive power is. That's been the second major prong of the argument. And that's all I'll say about sketching the argument. I think we'll come back and talk about a lot of this in the questions and the colloquy among us. Let me just offer 3 data points for how I've thought about this over in the last few years. And 2 of them are actually relatively new to me. Weren't things I really knew much or thought about when I first started getting interested in this question, really back in the early 1970s. One is the last one will be a much more familiar one. 2 of them are essentially British in nature. And I want to stress this because I think a big part of the argument that John and others have made does rely upon does rely upon the supposition that significant components of a British way of thinking about war powers issues were somehow imported into and absorbed by the framers of Philadelphia in 1787.